Good evening, this is John Milburn for LAWS12062 Alternative Dispute Resolution, and we are progressing into the term week 4, and this is census week. Next week we have week 5 and then we'll have a break. So tonight we're going to continue our discussion in relation to mediation and conciliation, which are really the forms of ADR that relate to the first half of this unit and culminate in the first assessment. Just a few words about the first assessment, the oral presentation. To some degree, I expect you to draw upon your acting skills. You may not have that in mind when you practice in law, but when you're an advocate or when you're an ADR practitioner in particular, you have an opportunity to showcase your skills. To some degree, I therefore require you to regulate your voice. Typically, some of the mistakes that I see during that first assessment relate to the tone and pace of speech. In short, people often speak too quickly. Now, you can say yes or no to this anonymously, but do you find that when under pressure, you tend to speak a little faster, change the way in which you'd normally speak? If so, then you may need to be conscious of that when you're dealing with your mediation session. Sometimes there's a temptation to race through something if you're a little nervous. And sometimes people say, yes, become a bit louder as well. So when you're dealing with the opening statement in your mediation or conciliation, be conscious of your voice, the tone of your voice, the speech at which you proceed. So, Jack's got a good idea. Hot tip, write slow down on some of the paperwork that you have. So usually it's too fast. Sometimes in the opening statements, there's an absence of tone. So provide some variety in the way in which you speak. Sometimes the pitch is too high, or maybe you have a tendency to raise an inflection at the end of a sentence, as if it's a question. So do be conscious of those little things. We all do it. We have fillers. I'm not sure what my filler is. If I asked you, I'm sure you could all tell me immediately. It might be an or an or it might be that I repeat something, but we all have fillers. So try to find out what your filler is, and without necessarily defeating it, try to minimize it. Sometimes people do things in terms of their mannerisms that they wouldn't ordinarily do. And there's nothing wrong with having mannerisms, something that we teach in advocacy. You have your space around you, and that's your space. So in mediation, it's fine to use gestures, to use your voice, to use the tone and the way in which you speak. These are all good skills. But in order to practice what is good, you might need to identify in relation to you what is bad, and that's a personalized thing. So be honest, maybe ask some questions of people that know you well. When you're having some dry runs with the people that you're working with in the group, ask for their feedback, and always be nice to each other, but make it positive feedback with an attempt to have a better way of proceeding. I suspect that you're probably thinking about the way in which you will present your dress for the assessment. There's no dress regulations, there's no dress code. In practice, most people would wear something that's either formal or semi-formal, and you'd wear, for males, usually a suit tie or at least a coat and tie, usually. For females, something similar along those lines. Given the time constraint, you probably won't have time, as we mentioned last week, for private sessions, but you might. And if you do, that's fine, no problems at all. And don't try and force an agreement. Sometimes we see like this desperate attempt to have an agreement. It's not going to earn you any extra marks. And in fact, it may provide a detriment to your work. So are there any questions about the presentation aspects of your first assessment? Anything that you wish to reflect upon and share with us as a result of what I've said? Do you disagree with what I've said? All good? All right. If you do have something that you wish to add, please feel free to unmute your microphone or use the chat facility and we'll go from there. Now, when you're preparing for your mediation, you need to still keep in mind the old IRAC methodology of legal thinking and legal logic. So there may still be room for issues, rules, application and conclusions, and there very often is in all mediation or legal work that we undertake. So those are things that you might want to consider as well. What I'm now going to do is just give you a little bit of theory before we continue with the practical application of the work. I'm going to share the screen and share this with you. Now, on the screen, you should see 5 words around a wheel. And that is Christopher Mohr's circle of conflict. And the wheel shows that in terms of conflict, there are a number of aspects that you need to be mindful of relevant to the participants. So it may be that people are influenced by their interests, by data, which is facts and information. It may be that they're influenced by structural matters or structural conflicts. We'll talk more about that. It might be that there are issues to do with relationships, and overlaying all of this, there might be issues to do with values. Now, as a mediator, you're probably going to invite the parties to concentrate on certain areas more than others. I'm going to invite you now just to vote. Of those 5, from a mediator or conciliator's perspective, what do you think is the most important thing that you should emphasise or seek to have the parties emphasise during the course of the dispute? So I'll just we'll have a look at the votes that are coming in on the chat facility. All right, so we're getting data gets a vote, but mostly, overwhelmingly, it's interests. And I agree with that. So in my view, it is interests that you need to focus upon, or at least invite the parties to focus upon. What do we mean by interests? Now, in any negotiation of any sort, people are going to voice what they want. And usually what they say they want represents a statement of their position. Position isn't there, but it's something that is usually foremost in people's minds. Now, here's my position on this. I won't budge. I want all the money and I'm not going to accept anything less. That's my position. It's what drives a person's position that we need to consider. And sometimes people's position is influenced by their fears, insecurities, their underlying values, relationships based on data and structural, but it doesn't necessarily reflect their interests. Now, structural conflicts may relate to things like power inequality or resources, and there's a conflict over resources, or it might be time constraints represent a structural issue relevant to the matter. So when we have structural issues that are imposed upon the parties, we need to be aware of that and to some degree invite the parties to reflect upon whether that is having some influence over their position and their decision making. It may be that as a result of structural issues, it's very difficult to run a fair mediation. So an example of a structural issue, which is really a power inequality issue, is, say, domestic violence. So if there is the real issue of domestic violence underlying the dispute, that structural conflict may need to be recognised, and as a mediator or conciliator, you may need to do something about correcting that structural issue. Now, the next thing is data, and data conflicts are very common. And essentially, the data conflicts may go to material facts or they may go to immaterial facts. What do I mean by a data conflict? Well, what I'm really talking about is information. And the information, whether it's right or wrong, may be relevant to the dispute in a real way, or it may be that a party thinks it's relevant, but it's not particularly relevant. So as a mediator conciliator, I come back to the fact that you need to identify the real issues and you need to consider the material facts without deciding the matter and still leaving it within the realm of the parties to resolve their own dispute. We need to identify what is the true information and what is the relevant information. So there may be between the parties a lack of information. There may be between the parties misinformation. And if you do have the same information, there may be different views on how to interpret that data or that information. So when you are undertaking a mediation, one of the things you need to do is think about the data, think about the information, and ask questions that might have the effect of unifying the information as far as the parties are concerned. In other words, if we're having a dispute in relation to, I don't know, an employment issue, it may be that one of the parties has information about the award, the other party has different information about the award. So it's obvious that there's either a lack of information or misinformation. And questions that might be asked respectfully might draw out the information that is relevant and correct so that we have ideally one set of data around which we're arguing. If the parties are working on different pieces of data, different information, then it may be very difficult to come to an agreement. So just for a moment, I'll stop the share for a sec. If during our mediation session it's obvious that there's either a lack of information or misinformation between the parties, can you think of any practical ways that we might deal with that? Any questions, any subtle suggestions that could be put forward to resolve that issue? How would we go about it? One party says, this is the reality. The other, right, so Gemma says, reframing questions to draw out information. Yes, that's a good idea. So we're looking to draw out the information, and it may be in the case of what has been provided by the parties that they're withholding information. Any other ideas? I know it's a hard question and it's hypothetical because we're talking about a situation that we're not talking a concrete dispute. All right, so one thing that I often do, pre-mediation, Mary says, yes, have them explain their position again, either in private or perhaps in front of each other, so that there's a better explanation. So draw out and to some degree repeat. So yes, Jack, I agree with that.
So just on that, it's just because as well as if they've said it, if it's stuff they've said privately, if it's information that's been obtained privately, that they may not have wanted to tell the full truth on it. If saying it in fact in front of the other person who may know the truth, may make them more free to give the information.
Yes, that's a good point. And you also raise a good point about the confidential nature of private discussions. So thank you, Jack. One technique that I use is to identify something objective. Now, it might be a map or a contract or a piece of legislation, a photograph or something, some objective piece of data. Place that in the middle of the table and then have the parties focus on that. So if there's a dispute where there's a map involved, often that can help because we can then start to agree on things. And remember that slide of the mediator saying, well, can we both agree it's a big yard? If we have misinformation, coming to common points of agreement is a good way to get it going. All right, so we can agree on this and this and this. Now, what are we actually disagreeing upon? Another way of doing it is, and you've got to be sensitive to this, is, all right, what are the important documents relevant to this dispute? Can we agree on a list of documents that we would present to a judge if we were presenting a common list of documents? Tim says, I've learned about discovery, documents and trial books at the office. Yes, exactly. So I'm thinking of a trial book or, say in the case of an appeal book, where the parties have an objective to come up with a set of documents that are relevant to the dispute. Now, if a party says, well, I think this is relevant, and the other party disagrees, that's an avenue for discussion then, isn't it? So at least we're coming to an agreement to disagree on something, and we can talk that through. It's an issue of an agenda. It's also a matter of trying to identify then what parts of the document, photograph or other piece of data are relevant. So we're looking for some commonality there in that situation. Let's just go back to the share screen and relationships. Now, why are relationships relevant? Because the parties may be fueled by emotion. And this often comes through in the relationships side of things. They might be particularly angry. There might be animosity. There might be poor communication between them. And the strong emotions will normally come out at the start of a mediation. So you've got to be on guard as a mediator or conciliator to that reality. People will stereotype, they'll exhibit poor behaviour, often very negative behaviour. There'll be miscommunication, there'll be statements which are irrelevant to the real matters, and your job is to try to encourage the parties to turn that around. So what are some of the things that you might do to deal with strong emotions, particularly at the start of a mediation, and some of the behaviours that would cause you to feel we're not getting anywhere? We've got to be careful here. This might blow up before we even start. So using the chat facility, what are some of the techniques that you can use to deal with that strong emotion? Mary says de-escalate. Yes, we don't want an escalation. We want a de-escalation. How do we achieve that? What do we do? What do we say? How do we behave? Paris says, just a question about, no, you get, it's an individual assessment, Paris, not a group assessment. We work in groups, but you're marked purely individually. Okay, so Jack says, what do we do? Have people write down their interests and feelings. Yes. Gemma says, reframe negative statements. Excellent. Tim says, establish some basic ground rules. That's very good. You're in control of the process. Tyler says, acknowledge the feelings, but then move forward. Acknowledging is very important. Thank you. Mary says, bring back the conversation to common ground. That's excellent. If we can do that, very good. Peter says, and this is extremely important, stay calm. Gemma says the same thing and adds confident. Nadine says, clarify that only one person can speak at a time. And Leonie says, each person has their chance to talk without interruption. Some excellent ideas there. So what you're looking to do as a mediator, conciliator, is create a positive approach to the issues, a positive approach to the problem. Try to encourage the parties to share this dispute as a common problem between them. And we're fostering a positive approach of we're going to resolve this. Thank you for coming to this mediation, this conciliation. It gives us an opportunity to assist you in coming to a dispute resolution. Paris says, try to allow the others to view themselves from the other's perspective. That's an excellent approach as well. So what we're looking to do is avoid the negative behaviours, try to avoid the repetition, particularly with raised voices, the stereotyping, and all of those things. Okay, the next one is values. Now, when we're talking about values, we can't separate people's problems and their approach to the world from their values to some degree, can we? We all have different ways of living. We all have different ideologies and backgrounds and views of the world. And we've got to acknowledge that part of the issues around this dispute might simply be because we come from such different places that it's very difficult for us to see the matters from each other's perspective, but we must try to do that. So different people have different ways of evaluating disputes, and Mary says we've got to make sure that we're neutral, and that's really good, and actually state that. That's a very good point. What can we do when we're dealing with issues that reflect different values? Realistically, practically speaking, different values, how do we deal with that? I'm sure that we've got some typing coming through. Here we go. So Tim says, it's hard not to stereotype, especially when you know very little about the parties involved. Yes. Acknowledge that they are important to the person. Ignore your own, but acknowledge the parties. Remain impartial. Yes, it's very important that we don't show any of our values coming through here. We've got to remain impartial and neutral. It's all to do with professionalism. If people do have values which are very obvious, I think acknowledging them, as Peter said, is important. It's important to you. You know, one party may not be at all religious or in their beliefs. The other person may be. And acknowledging that we all have this different view of the world is important. I think it's important also that we allow people to agree and disagree. And allowing them to disagree is sometimes a very positive approach. But do that within the context of all of those things that we do agree upon. So we're very fortunate that we agree on so many things, but it's okay to disagree on things. So acknowledging the values that people come with is important, and treating those values with respect, treating the people with respect in relation to their values is important. But don't try and necessarily change the world. We're not there to do that as mediators. And if you start to step down that way, then we run the very real risk of being perceived of being far from neutral. So acknowledge that people have different values, yes, is important. So let's now look at what it is that we do want them to do. We do want the parties to acknowledge all of those things that we've talked about, but ultimately, in my view, it's a matter of trying to work the parties towards a position where they are truly dealing with their respective interests. We know this is emotional. We know that we have different views of what the data says. We understand that there are power imbalances in this relationship, and that each of you come to this discussion, this mediation today, with different values and backgrounds. We understand all of that. But ultimately, what we're here to do is encourage you to think about what is in your best interests. We know what your position is, but we want you to think about what's in your best interests, think about what's in the other party's best interests to some degree, and see if we can work together to resolve the issue. So someone had earlier said, encourage them to think about it from the other's perspective. That's a very good point. Think about what it is that is their real interest in this and not their perceived interest or their position. You know, my position is I want every cent paid to me because I'm entitled to it. That might be a position, but your interest really is to resolve this litigation so that you can wake up tomorrow morning and think, that's behind me. I can now get on to some other things. And all of those things that have been neglected over the last 2 years while I've been involved in this dispute can suddenly start to be done because I've now got some time and some money and I've got some emotional space. So we need to look at the interests as much as we can and encourage the parties to do that. Okay, no questions? All good? All right, let's continue. So you can see that your ability to communicate is critically important in this process because your task is to de-escalate, acknowledge, encourage, and then be the conduit for the discussions. And you're doing all of this in real time, and it's not easy. So, having some standard questions and some standard techniques will probably be something important to do. And I'd recommend that you start to do that now. Something that works for you. During the week, look at any dispute, whether it's on TV, you know, down the park, whatever, and think about, okay, well, if I was the mediator or the conciliator, how would I go about in the middle of this dispute? What are some of the things that I would want to do or say that might help? Now, one of the standard ways of dealing with this might be to have a question that says, well, you know, what are your strengths and what are your weaknesses? So we're doing the BATNA and the WATNA. You might do that in private, but that's something that you might keep in dot point as a fallback position if you're really getting stuck. Another is to deal with issues around the knowledge and just ask some questions. Again, more likely in private sessions than not, but do you have the technical knowledge to give you the confidence to know that what you believe to be the case is in fact the case? You might raise that with the parties in open session. If there is a distinction between what the parties say are the facts, what are some of the ways that you might assist the parties to come to a resolution on that point? Are there any standard questions you might ask? Any standard approaches that you might intervene with to assist? Any suggestions? The parties don't agree on the facts. What do we do about that? Is there anything that we can do during a mediation session other than acknowledge it? Find where they disagree, says Jack. I really like that. Very often people will talk in general terms. They won't talk in specific terms. So let's break that down. Find out where you agree, find out where you disagree. Perhaps you might have reference to something objective. Peter says, find even the littlest point of agreement. That's right. If you can judge some facts by way of reference to objective criteria, that might assist you. And it may even be part of the agreement. So the agreement might say that ultimately the parties agree to engage an expert in this field to answer this specific question and then following receipt of the answer to resolve the matter on this basis. So it might be, okay, you really can't agree as to what was the prevailing interest rate during the period of the dispute. What if we come to an agreement where a nominated person makes a statement of fact, and once that is decided, this is what you'll do. So that's an idea. But you'll need to think about some of these techniques and jot them down. Now, a very common matter is a thing called reframing. Now, who mentioned reframing earlier? It was right at the start. Thank you, Gemma. So, reframing. What that means is taking what has been said to you and communicating it back to the party, but in a different way. What you're looking to do is to take the essence of what is said, stripping away all of the emotive, subjective, irrational comments, so that we're now starting to deal with facts rather than a tirade of abuse, if you understand. So we're taking the essence of what was said, we're stripping it back, and we're saying it back to that person in a positive frame. I hope that makes sense. All right, can anyone give me an example of reframing? You've got the advantages of the slides here in that sense. It's all to do with different perceptions in many ways. No examples coming through?
So I think I've got my hands full at the moment, so I can't type. But I think just taking the bias out of a statement made by one party and then reframing it without that bias. So where they might think that they're hard done by for any, sort of reason, you say the question back without that bias.
Yes, that's right. Thank you very much, Gemma. So you're stripping it back to something that is more factual. So what you're looking to do essentially is to transition to the positive. You're trying to take something that was highly emotionally charged and negative in its nature and its delivery and turn that around into something positive, because we can work with something positive. So it's this transition from the negative to the positive, and in the same way presenting a possible solution that is the art of reframing. So a statement. He never tells me what is going on with the company's finances. That's a statement that is made during a mediation. The response might be, okay, so you would like to have more direct access to the company's financial records. Is that correct? Yes. Right. So we've taken the negative statement, the personalized statement, the finger pointing, you never do this, strip that back and make it a positive response. Okay, let's look at something that is doable. Let's look at a way of solving the issues rather than the personal attacks. So another one is to transition to the future. So we're looking in reframing to make something positive. We're also future focused. So we're taking something that is based in the past, transitioning it to, this is the way we can resolve this in the future. Statement. My daughter was such a lovely girl. I do not know why she has become so bitter. It's a statement about the past. Your response as a mediator in reframing might be, so you love your daughter and you want a caring and mutually respectful relationship with your daughter. Is that correct? So you're looking for something into the future. My daughter was always bitter. Okay, we understand that. But into the future, this is what you want. And we're reframing in a positive manner. Reframing is also important for this general transition to interests. So the purpose is to concentrate on what really matters rather than the position the party is taking. So a statement might be, I cannot live this way. With all that noise coming from my neighbour's property, I am not sleeping. So your response, take that, strip it back, present it back, providing the essence might be, so you like where you're living and you want to maintain your lifestyle. Yeah, that's it. You can understand that if you reframe correctly, you will get an acknowledgement from the party that had given this emotive statement and say, okay, yeah, I get you. You understand me. You understand my problem. And it's also a way of transitioning into the future and having a positive discussion. So reframing also provides an opportunity for a shared approach. So the statement might be, he's so stubborn. He will not even think about how we can pay the school fees. How do we respond? Shared approach. So it's important to you both to consider how to pay the creditors. Is that right? Yes, get an agreement. If one of the parties says no, then it's an avenue to challenge that approach. Why isn't it important that we pay the creditors? Isn't that a shared problem? We're in this together, aren't we? So try to reframe in that positive way. So reframing, of course, is very important. What it does is it shows that a number of things. The first is that it shows that you've listened very carefully. You've actively listened. It's not just an acknowledgement and go on to the next sentence. Because the reframing is often done at the start of the mediation, without interrupting the flow of the participants so that they become frustrated, at some stage, fairly soon in the process, you need to intervene. So another challenge to you as the mediators is to reframe at the right time. Now, if you go into a mediation session and it's highly emotionally charged, you may have to do something before you reframe, and it's called sponging. Has anyone come across this term, sponging? All right, anybody like to tell us what sponging means? I've already said it's likely to be at the start of a mediation session. Who wants to use the chat facility, or better still, even unmute? Anyone? Sponging, what does that mean? No takers? What does sponging mean? When would we use it? Okay, so Tim says grinding off the rough edges. Yes. So sponging is really dealing with an emotional outburst. It's usually at the start, and it often is one party, or maybe even both, for want of a better term, really mouthing off, really having a go. What you need to do is try and absorb, Mary's onto it, and Peter's onto it too, absorb some of that emotion. So what you're looking to do is, unlike the usual practice of a mediator or conciliator, to direct the attention of the parties towards each other. If you get a bad example of an emotional outburst, then bring the attention to you. You do that subtly. Try not to be overt about it, but often using your hand is a good thing. Look at me. Look at me. Why? Even if you move forward, people will naturally look at you, won't they? If you move forward and set up a bit, then they're likely to direct that outburst towards you. You need to absorb this emotional outburst, often at the start. It's not counselling, but what it is You're demonstrating positive body language. You are smiling, but respectfully. You're showing something other than displeasure or anger. You're actively listening. You're acknowledging. You probably don't have a realistic opportunity to reframe while they're in the middle of this tirade. You're building an emotion of trust, and then when the time is right, you can move in with some techniques to deal with this outburst. All right. And at the same time that you're doing this, you're very conscious of the other party because you don't want them to get up and leave. Because if this tirade is directed to the other party directly, chances of them getting up and leaving are enhanced. If it's towards you, you'll probably be able to keep them there for a bit. But you may have to use your hand just to acknowledge to the other party, I know you're there, don't worry. I probably can't see it on camera. Using my right hand to say, I know you're there, don't worry, we will get to you, but just let me deal with this first for a moment. And people kind of respond to that pretty well. So in your mediation conciliation session, you might have this. So once you've received this initial outburst and you've not let it go too far, what do you think? Peter says, show empathy, not sympathy. That's a great point. Mary says, absorb the emotion, diffuse, reiterate the rules, or time out, or other ways to restore order in a calm way. Mary says, you're not being judgmental. Lower your voice. They may lower theirs as well. And Tim says, I can't speak with my hands. All right. So when you have this initial tirade, odds are that once a person has stopped speaking after 3 minutes of a bit of a rant, provided you've been able to keep the other side there and not moving, the first party is likely to run out of steam. And that's your opportunity to move in. And the way in which you move in is important. Now, the first is, Tim says, I can't speak without my hands. Yes, that's more like it. That's what I thought you might be saying, Tim. You can't move in too quickly because if you try and interject really soon during the sponging process, then it might become into an argument between you and the other party if they're shouting. So you're using positive language to try and diffuse it, write it out, and then when you can, build this environment of trust, both to the party that was providing the initial tirade and the other party that's sitting by the side trying to be patient while this is going on. We had some comments here about the way in which you might question. Ask some open, exploratory, or clarifying questions. Not exactly reframing, but asking for more information. And without necessarily reframing, you might be in a position to summarize. And you might be summarizing to do a couple of things. The first is you might be summarizing in an attempt to create your agenda items, or you may be summarizing in order to transition into something more important. I was going to say important. It's very important to the person concerned, but when I say important, I mean real issues. You've got to remain impartial and fair, calm and relaxed during that process, and somehow you've got to give equal attention to the parties. That's what I mean by keeping the other party aware that you know they're there, we'll get to you, and you do. So you help to try and keep the communication in a positive way, but at the same time fair and positive, fair and respectful. That can be tough. If someone is really being horrible, you may have to call it quits. There was a thought there, I think Mary said, maybe take some time out. In extreme cases, you might have to do that. Otherwise, it's just not fair. You're still in charge of the process. You can't allow people to just go over the line. But where that line is depends on you, and it's very subjective. And you might have 4 very experienced mediators who have different views of where you should jump in. I probably am at the end I probably allow people to go longer than others might, but I found that that's effective provided you can keep the other party interested and attentive. Because if you let them burn out, we then have a platform for positive discussions. Silence can be good, because sometimes if they run out of breath and they expect you to respond and you don't, just for a moment, they might get the hint. Okay, well, maybe I should settle down a bit. Pause, yes, can be very effective. So in your mediation session, I might be looking for that. Encourage reflection, says Mary as well. So you're trying to remain attentive. You might start to reframe, and eventually you might start to encourage the parties to think about positive ways to resolve their issues. In essence, what you're looking to do is detoxify, aren't you? And this is part of reframing then. It's all positive steps. And you'd be surprised the number of times where there is a really hostile situation, but the parties eventually settle down to the point where you have succeeded in making, in their eyes at least, a couple of friends, that they might trust you enough to think, yes, this is something that I can deal with this person. I can see we're getting somewhere. All right, so yeah, there is a bit in this, but it's a matter of practicing and identifying, so that when you showcase your skills, I can see, yes, that's a summary. You've summarized that well. You've reframed that well. You've detoxified there. You've calmed the other side. You've given equal attention. And you've got to do all this seamlessly. It means relying on your acting skills, as I mentioned at the start of tonight. Sometimes you need to do some reality testing. Now, can anyone tell me what I mean by reality testing? What is reality testing?
Is it where the person actually has lost the track when it comes to actual reality, and so therefore you've got to be very careful in then, you know, bringing them back to what's realistic?
Yes, that's right. So when we're talking about reality testing, I'm not talking about, you know, little green men and Martians and space rockets and things like that, but what is really going to happen in the real world, as is what Tim suggests. Leone says, checking the evidence, reality-based material. So now, Jack, you'll have to help me with that.
Oh, sorry, sorry. The common acronym at work. FASD stands for feasible, acceptable, suitable, sustainable, and discernible.
I like that, but I'll have to get you to put that onto Moodle, please, so that we can. There'll be a few repeating that. I really like that. Thank you. So could you just repeat that for us again? Thanks, Jack.
So yeah, it's feasible, acceptable, suitable, sustainable, and discernible. We use it for course of action testing. So is a course of action going, like, you think of it like the brainstorming, and then this is where we use to say, is this going to actually potentially happen?
Excellent. And Gemma says, will it actually work? Thank you very much for that contribution. And you mentioned my next one. That was a good segue into brainstorming. So what do we mean by brainstorming? And can anyone tell me when you might use brainstorming?
When you're at the point of looking at the common ground and possible solutions that could be, you know, agreed by the parties.
Yep, exactly. Very good. Gemma says looking at options. Tyler coming up with options. Tim says thinking outside the box. Yes, all of those things. So reality is important in brainstorming, in that there are no stupid ideas to start with. Yes, very good point. So I'm going to ask you a question here. Do you think that brainstorming would usually proceed or follow reality testing? If there was an order in this, and there is no theory, which do you think normally would come first?
Depends on how unrealistic they are as to where you would bring it in. You know, if they're way off the beam, you know, Little Green Men or something, you may have to, you know, bring it in then, but normally afterwards, I would say.
As in brainstorming first and then reality testing?
No.
The other way around.
Revealed that they're, you know, beyond the realm of realism, you could bring it in there, but otherwise, if that's been resolved, then afterwards.
Okay, thank you, Mary. All right, so any other thoughts on the timing? If you were going to engage in your session in brainstorming and reality testing.
Also, if there was an opportunity that came up at any stage, where it felt appropriate, everyone was in a calm frame of mind, and then you could put it out there and just see what comes from it.
Yep. So with reality testing, there's a great inherent danger. It's a very valuable technique, but can anyone think of the inherent danger to the process if reality testing is not done well?
It could bring the proceedings to a halt.
Yes.
Stop.
Why, Jack?
Because people will feel like their ideas may not be valued, or that they can't see a possible outcome. Sort of the forest for the trees kind of thing.
Yes.
That's why brainstorming should go first, because there's no dumb ideas. All ideas are valuable in brainstorming, and then when you start, that's where you start segmenting them and bringing them down into what the right, feasible ideas are going to be.
Yes, I strongly endorse those comments. Thank you.
I was going to say there
Yes,
are
Mary?
some situations that I've been in, having done this a lot in parent protection matters, where reality is just so, you know, oppositional and, you know, in contravention of the evidence that's black and white, that you just can't run with it at all. You know.
Yes, so it's just too unrealistic.
That's what they are in the belief of, and nothing anyone says or does is going to change that.
Yes, another thank you, Mary, for that. I agree. One other problem with reality testing is that if you don't do it correctly, it could easily be perceived by a party as bias. So you could imagine if after the opening statements, someone says something and you ask the question, do you really think that's feasible? They might think, oh, they're against me already. We've only just started and already they're against me. Gemma says it could also sound condescending. Absolutely.
It'd be better to acknowledge their reality as being, you know, the belief that they hold. If you can't do anything about, if you're in a position where you can't actually, you know, get them to see reality, and that's recognised maybe by a pre-session, you're quite aware of that. Sometimes it's better just to acknowledge that that's their reality, that's their belief, and they're holding strongly to it, and you can't change it. So,
yes, which reflects some of the things that we were talking about earlier this evening, wasn't it? Different values, different perceptions, different ways of looking at the world, where we were saying be respectful and acknowledge. Look, I think once we've heard from the parties in their opening statements, there's nothing wrong with asking open, clarifying questions of the parties after we've set the agenda in the first joint session, in order to glean the facts and identify what are the facts, with a view to determining here's what we agree upon and here's what we disagree upon. It's not reality testing. It's open-ended questions to draw out information. Now, as you do that, the penny might drop with some people and they might think, oh, I understand, but often that won't happen. So I think, generally speaking, after you've created the agenda items, that you might ask some open clarifying questions in open session in order to draw out facts. You might then look to see if we've got some common agreement in relation to facts, identify where we disagree, and then engage in a relatively lengthy first session. If you're getting towards the end of that first session and we really haven't advanced much, I think having a brainstorming session is a good time then. I think it's a good time for a brainstorming session. And sometimes I actually change approach and say to the parties, almost as if to say, look, can we just forget about this for a minute? We really have to get this resolved. I'm struggling here, so I need your help. Are you both willing to help me with this? I want you to both come up with some ideas. It doesn't matter how silly they are, as Jack mentioned. Let's just brainstorm some solutions, and then we'll talk about it. So I don't necessarily say those exact words, but I give that impression. So then we have a brainstorming session, and we can talk. It might generate some new discussions. It might come up. Someone might come up with something and say, "Yep, I like that idea." Then I think you'd go into private sessions, and in those private sessions, I think is the opportunity realistically to do reality testing. It's very dangerous to do reality testing in a joint session, but in a private session, I think you can sit with the clients and they know that nothing that they say to you or you say to them will be repeated to the other side. And it's a chance for you to say, all right, let's see if we can think this through. Now, you can do reality testing on common ground, but just make sure it's not perceived to be biased or, as Gemma said, condescending. So any questions about that process? All good? Any comments? All right, so when you're dealing with these matters in reality testing, often you're talking about the BATNA and the WATNA, and you're talking about the cost associated in time and money, and very often ignored is emotional cost. And I do say to people, please now picture yourself as in a situation where we've resolved this matter, it's finished, it's no longer part of your life. How do you feel when you wake up in the morning? How do you expect that you'll feel? Now, if they say, well, I think I'd feel better, it gives you an opportunity to ask them to reflect upon to what degree are they willing to pay for that feeling of being better. In other words, this may not be what you want, and you may be paying something in whatever terms it might be to gain that feeling, but ask them to consider whether paying something is worth the feeling of relief. And when I say paying something, I might mean not pursuing something, whether in dollar terms or otherwise. Okay, we might leave it at that unless there are any questions or comments. All good? All right. Thank you for your patience, and we look forward to seeing you next week. All the best. Bye then.